The first case to come before us is State versus Anderson, and it looks as though you're appearing alone. And so you will have the full 15 minutes.
Thank you. May it please the court, my name is James Armstrong and I represent Robert Anderson in this matter. Your Honor, we have filed assignments of error based on insufficiency of evidence, manifest weight of evidence, and the non-granting of the Rule 29 motion. Your Honor, the troubling aspect of this case is the description of the accusers and the defendant's relationship. I concede that I don't really understand what friends with benefits means and what the definitions are and what the rules are in this situation, and that's where the problems come in with this case. And if there's a little bit of rubber in my brief, I apologize for that, but if you're friends with benefits, and that's the way it's described by the accuser, how do we know when the benefits are permitted and when they're not if somebody doesn't let you know?
Well, they can't let you know if they're asleep.
Well, but the evidence, Your Honor, indicates that she awoke and said nothing. And I'm looking at this from the state's case, awoke and said nothing. She was at the home of her mother, her sister also lived in the house, did not say anything there, and then contacted Robert Kiefer, who was supposedly another friend of hers who she described as her little brother. It was only then that she said that Mr. Anderson, her words, raped her. At that time, EMS was called, at which time she said she had no pain. And literally 23 minutes later, at the SUMA emergency room, she's complaining of 8 out of 10 on a scale of pain at that time. And the ironic part about that is Kayla Beers, who was the SUMA nurse, was actually the same nurse when she came in a few weeks later, complaining of the same pain, and then mentioned that she had endometriosis as a medical condition, which would have caused the very pain that she was talking about at the SUMA hospital. It's the troubling also aspects of this is that it appears that, well, I know the court has held many times that the jury is the finder of fact and they're allowed to judge credibility, but when the accuser's mother and sister both question her credibility, and the accuser also talks about her mental health issues, it seems that in this instance, that the only person or people that actually did believe the accuser was the jury, because even her own family had questions about her credibility on the subject based on her history of this, of her lack of honesty. And then when you tie that in with the relationship she had with Mr. Anderson, where she described him as her best friend, her children called him Uncle CC, they were friends with benefits, they lived together.
What was the time frame for that? Because I thought in reading the state's brief that they had in the past had the relationship that you just described, but by the time this incident took place, that relationship had ended and she was in a relationship with someone else.
Well, I believe she did testify she was in a relationship with somebody else. She was having the relation she had that she admitted, and again, I'm looking at this from the state's point of view since that's what the court's rulings have been in the past, that she had a relationship with him in, I believe it was around the middle of September, maybe September 10th, 11th, 12th, somewhere like that. Her exact words were after she got out of the psych ward, where her actual testimony. I kind of felt bad for Judge McKinney, who issued a ruling not to allow that in, and then she volunteered it on the stand.
Well,
but
you know, that notwithstanding, even though she may admittedly have had mental health issues, that does not mean that she could not be victim of this rape.
You're absolutely right there. Well, sexual battery, the rape charge was actually, she was found not guilty of the sexual battery. I completely agree with that. But she's the one who defined their friendship as friends with benefits, the benefits being sexual contact.
And that was my question, whether or not the state was incorrect in indicating that there was a defined time frame for that aspect of the relationship, and that by November it had ended.
Well, but at the trial, the accuser says friends with benefits, and that's how she described the relationship. It's the reason why I pretty much started off by saying I don't really know what the rules of friends with benefits means, whether that's allowed as long as you're dating somebody else, or it's not allowed, or it's only at one person's allowed to access those benefits and the other person isn't. Because sexual battery, if I remember the elements correctly, is knowingly on the part of the defendant. And how is the defendant supposed to know without any verbal confirmation? If she wakes up with the tight jeans and the leggings pulled down her ankle and they say, "Get off me," and he continues, well, we also may have a rape situation there too, but there's a clear message there. When you don't say anything with somebody you've had a relationship with, and like I said, the accuser refers to as friends with benefits, are you allowed to access those benefits at that time without her saying anything? That's the troubling aspect of this case. You know, how is one to know? I've been married a long time, so these rules have all changed, obviously, since I was dating. But how is one to knowing that it was not permitted, with somebody not saying anything, and it had at least been permitted in the past? And we're talking maybe 8 weeks earlier.
Well, I would say two things. One, a spouse can be raped.
True.
And number two, I'd say, wasn't there, and I can't remember, to be honest with you, was there evidence, any type of testimony that he had already digitally penetrated her prior to her waking up?
No, the evidence was that he was unable to perform, but I believe she testified about possibly a finger in the vaginal regions with regard to that. And since this is sexual battery, and I don't have the elements right in front of me, I don't think that applies to, I think it's specifically not married to the person. Since it's not rape, it's sexual battery. I don't believe a married couple can, a married person can be charged with sexual battery. They can be charged with rape, of course.
But they weren't married.
They were not married.
I just thought there might have been something that said that by the time she woke up, he was trying to
He was trying.
penetrate her.
Yes, but he couldn't.
Right.
He said he couldn't.
That's
And
what he said.
in fact, he said that to the, he said two things to the detective, that he said, one, he couldn't perform, and the second, he said he was stoned out of his mind and really didn't remember much. Which certainly doesn't, help the situation as well.
But like in this case or anybody's case.
But it is a fact that the court must consider, and I've never misled the court ever, and I don't intend to start now with this case. The real troubling aspect of this, though, is the nature of their relationship and the knowing aspect of Mr. Anderson, and the ability to know that no, it wasn't permitted here, no, get off me, was never said. It was until after the fact, and then you have the state described it as minor inconsistencies. I don't think they're minor inconsistencies when 23 minutes later you're in horrible pain, but you aren't in pain at EMS. You complain of issues at the emergency room, and then 3 weeks later, because of a medical condition, you're complaining of those same issues. And the underlying fact that the entire, pretty much her entire family said this is not somebody who's trustworthy. That's quite a better pill to swallow to get convicted based on those sets of facts. So at a minimum, I believe the jury kind of lost their way, because there's no real clear understanding as how did they come to the conclusion that he's not guilty of rape but guilty of sexual battery based on the same set of facts, essentially.
Well, it may very well have been that just what you articulated, that she was asleep, and when she woke up, she did not protest verbally. Perhaps they took that into consideration for the rape, but in terms of the sexual battery, that the penetration had already taken place before she woke up.
Unfortunately, we don't really know what the jury was thinking when they came back. we're left with the transcript that probably adds more questions than it answers with regard to the various testimony that came in, and along with the other issues that were involved. And for all I know, the jury may have come back with sexual battery because they felt sorry for her, and they don't want to be in a situation where they didn't believe somebody because she had mental health issues and her whole family didn't believe her. I don't know the reason for the jury. Maybe, and I'm not saying just where you're saying this, but maybe they did go, well, we don't want to find rape, but we want to find something. I can't answer that question.
Well, of course, we have to presume that they followed the instructions.
You have to presume they followed the instructions, but when the instructions are provided and then the verdict is given and you're reading the transcript and the question is, okay, I'm a little lost how they came to that conclusion, considering all the troubling aspects of that, especially the knowing aspect. I think I'm more trouble with the knowing aspect with regard to the defendant here, Mr. Anderson. Do you know, how was he to be aware that she did not want to provide, quote, benefits at that time?
Well, let's look at this from the standpoint of, let's say that they were doing drugs together and she was just completely incapacitated, unable to give consent. And he decides that, well, she's here, I'm here, I want to take advantage of the situation. Where does that take us?
I think that would be clearly a situation where the person would be guilty of not a sexual battery and actual rape because of the incapacity nature of it. But in this case, the facts don't indicate that she was awake. There's also an issue with regard to was she really awake. I mean, when you consider what she was wearing and how difficult it would be to remove, those types of articles of clothing and how, I mean, that's a pretty sound sleep.
And there was testimony to support the fact that she was a very sound sleeper, as well as testimony that while this started out being 3 people in one another's company, that once she fell asleep, your client invited the other person to leave.
I think that was Mr. Kiefer.
Right. So.
But it also indicated that her mother and her sister were in the house at the same time. That's.
When the police guys were in the garage,
they were in the garage. It was a garage apartment. That's how it's described.
Separate from the house?
No, it sounded like it was attached to the house. I honestly don't have the answer to the question, and I don't remember from the transcript if it was clear, but it sounded to me that it sounded like it was an attached garage from reading the transcript. That's how I visioned it while reading the transcript. But it's for those reasons why I believe that if the court isn't comfortable with an outright reversal, that certainly a new trial in this matter would be appropriate to allow a jury to allow the client to have at least an understanding of whether or not strike that. It appears that the jury lost its way, and we can't honestly come to a conclusion as to how they came to this conclusion based on all the troubling statements and inconsistent statements made by, in a sense, the only witness. And in the interest of justice, a new trial would be a much better alternative than having somebody continue to serve 5 years with less than compelling evidence to support that conviction.
One last question, at least from my perspective. I thought that I recall that when your client was initially questioned by the police, that he denied being there after this young woman fell asleep. In other words, that he said that he had left before the other young man left, and then later backtracked and changed his story. Is that correct?
I don't honestly remember that part. I'm not saying that didn't happen, that may have happened. And the problem I'm having, Your Honor, is that sometimes my cases get confused, and I'm trying to remember what facts are this. because I don't think he denied in talking to the detective that he was with her. Now,
No.
It does say that he interviewed, the brief, the state's brief says, detective interviewed Anderson, who reported to him that he left prior to Keeper leaving, and he further reported that this fellow was awake when he left, according to the state's brief.
but I believe he later stated that he
Recanted
was,
that.
recanted that, yeah, because that's, and when that happened, I don't know, and the other issue is when he says that he was, I think it was his words actually, that he was stoned, was the words he used in the description of the detective, because of all the marijuana he had smoked that day, which obviously didn't improve the situation, but is a fact to consider.
Well, thank you, Counsel.
Thank you, Your Honor.
Thank you. We'll take the matter under advisement, issue a written opinion will be sent to you and the state of Ohio, and it will be released on our website.
Thank you very much, Your Honor.
Have a good day.